Hello and welcome back to the Friday Five for December 2nd, 2022. My name is Andrew Ayers. I'm an estate planning and business law attorney. I've got offices in Edina, Minnesota and New York City. We're going to look at 5 questions that came up this week in different consultations and different meetings with clients that maybe will be helpful for you in your situation. Obviously, first of all, I hope everyone had a wonderful Thanksgiving holiday. We didn't do a Black Friday edition of the Friday Five because I wasn't here. The office was closed, and hopefully everybody else was also enjoying time with their family. Question number 1 this week: do I need to tell my lawyer about prior estate planning documents? The short answer to this one is you don't have to, but it's a really good idea. So this week I was speaking to a client who wants to create a brand new estate plan, and we've been going through the process and we started setting documents up. And then that client mentioned that he had a trust drafted years ago. And that changed the dynamic of things, because if we have a prior trust, we need to look back at that trust and see whether or not it needs to be amended or restated. But also we need to look at whether there's assets in that trust. So if you previously created a trust, you can't then just create a whole new estate plan and pretend like that trust never happened. So if you had a prior estate plan, those documents will likely be revoked or overridden by whatever documents you create now, but it's important that your attorney knows about those prior documents so we can look at what's in them and see if there's any other changes we need to make to them, or make sure that your estate plan is properly encompassing what you've previously done for your estate planning. Number 2, can I use my trust to avoid probate? I had an interesting phone call this week where an elderly man was using a trust to be able to be very specific about how he wanted assets distributed after he was gone. And the reason he did this is because he had biological family members, and then he had non-biological people that he treated as family members. He had actually raised 2 people as if they were his own. They weren't technically biological, but something had happened to one of their parents, and so he was essentially acting as a parent to them growing up. He's been a mentor. They're like family. They spend holidays together. And he wanted to make sure that when he created an estate plan that he was providing for both his biological and what he considered his family, who was actually non-biological. And so without any kind of an estate plan, the law in New York, where this was situated, would actually not be giving any money to these non-biological family members. So correctly, what he did was create a trust to make sure that we have distributions for both the biological and non-biological family members. And in this case, that may create some issues, however, because the biological family members may feel like they're receiving less than they thought they were going to get because of the presence of the non-biological family members. Number 3 this week: is my property in my trust if I don't file the deed? So it was an interesting circumstance where a client came to me and had a trust set up years ago, and had under that trust, the idea was that their property should be moved into the trust. They went so far as to actually create the deed, sign it, everything's all set, but they didn't record the deed. Apparently their advice was leave it until you're dead and then you can file at the time of your death. I wasn't sure about where this advice was coming from, because that's not something that I would ever recommend to my clients. Because for the asset to be in the trust, in the case of real estate, you have to file that deed with your county. And oftentimes you create a deed and you sign it, and when you send it in for registration, there can be a little problem. Maybe there's something mistyped here, the description's off, or somebody forgot to check a box. Well, if you're already dead, there's no way to go back and fix that deed at that point because the grantors are already dead. So we want to make sure that we get those deeds filed so that if there's any problems, we can take care of them while you can still fix that deed. Because after you're gone, you can't then fix that deed because the person is dead. Number 4, how firm are discovery deadlines? So I'm working on litigation, and we have certain discovery deadlines that we're coming up against. And my client asked me, how firm are these deadlines? The simple answer is they're probably not as firm as you initially think they are. So if your case just started and you received, let's say, a demand for interrogatories, and it says they have to be answered within 30 days, you might get a little bit nervous. You're a client, you've never seen these before. There's, let's say, 75 interrogatories. There's a lot of questions to answer, and it's giving you stress, and you're not sure what you're going to do. Talk to your attorney first, because oftentimes you can speak to the other attorney and say, listen, there's 75 interrogatories. We need a little more time, and you can create a schedule that you can work with. The flip side of this is if you've had a case that's gone on for a long time, it's been a couple of years, and especially with the pandemic for the last couple of years and court closures, a lot of the timelines are off a bit in the courthouse. However, if you have an order, like a scheduling order from court that says a hard deadline on discovery, that's a deadline you need to pay attention to. That deadline can be a lot harder to move than an initial deadline of early on in the case we're serving some interrogatories. Number 5 for this week: how do I terminate a contract? So I have clients who have entered into a couple of contracts, and now they need to get out of the contracts. They're doing something different. and they don't want to be in the contracts anymore. And we've talked about this in prior videos, but the most important thing to do is read the contract. What does the contract say about how you can terminate the contract? And what you want to watch out for here is that the contract allows you to be the one to terminate it. So in a couple of these contracts that my clients were dealing with, they actually didn't have any ability to terminate a contract. There was no provision. The other party had drafted the contract. The other party had about 5 or 6 different ways they could be the ones to terminate the contract, but there's nothing from my clients to be able to do to terminate the contract. That doesn't mean that you can't get out of the contract. It just means that you have to figure out a way to properly notify the other party that you're seeking to terminate the contract, and you want to make sure you have good grounds, because they may actually try to fight you on it and say you can't actually terminate the contract. So it's December 2nd. We had snow here in Minnesota earlier this week. It's been pretty cold, but we're getting ready for the holidays. A couple more weeks to go. So that's our 5 questions for this week. Do you need to tell your lawyer about a prior estate plan document? Can you use that trust to avoid probate? Is property in your trust if you don't file a deed? How firm are discovery deadlines? And how do I terminate a contract? I hope everybody has a wonderful weekend. There'll be a link in the notes to this video if you'd like to submit a question for upcoming Friday Fives. And if not, I hope you have a great weekend, and we will see you next week.